Today, we're going to talk about the estate planning spectrum. If you're a human and you live in the United States, it is very important for you to get an estate plan. An estate plan is a series of documents that tells people what to do with your assets and items and who to give them to at the time of your death. Now, many people do not engage in estate planning. It's something like only 30% of the entire population of the United States has actually put together on paper some of the things that they need for an estate plan. And that's because a lot of people have the misconception that they are not going to die. Guess what? You are. You definitely need an estate plan. But the complexity of the estate plan that you require really depends on the spectrum of where you are in your life. My name is Lauren Glynn. I'm an estate planning attorney here in Cooperstown, New York, and I specialize in helping families leave legacies that they can be proud of for their future generations. So, for our estate planning spectrum, there are certain tools and certain things that make us go forward. Our most basic estate plan is our last will and testament. You'll often hear people say, I need to get a will, a last will and testament, because then I will avoid probate. That is not how wills work. Wills require probate because probate itself is the process of proving that a will is a valid document. But a will is a basic document for our estate planning, and it's where everybody should begin. If nothing else, this type of document, all it is a series of wishes written down that states what you want to have done with your assets. Whatever it is, these go to these certain people. It allows you to choose an executor, and then you'll know who's in charge of your estate and where their things should go. Having a will, while it won't avoid probate, will avoid a lot of family discomfort and a lot of uncomfortable conversations. After the will, the next step up in our estate planning spectrum is called a revocable trust. So, a revocable trust is a document that works to avoid probate. This is something that when we put assets inside that document will own those assets, and then those assets move to the next generation through the actual text of that document. No court required. This is a really great tool as people start to age up in life if they have things that are an interesting asset makeup, maybe assets or property in multiple states across the United States, or if people have a family situation where their family may have some complex ties or needs, and I can't just give them something outright through a will. It will impact either their benefits or they're not the type of people that we can be trusted to not just spend everything at once. So if that's your family, then you're going to be looking closer to a revocable trust. Moving forward in our estate planning, when we start getting to, all right, we're in our elder years and it looks like something is imminent, we're going to look at irrevocable trust planning. An irrevocable trust is a trust that is permanent. It is something that we cannot alter or change once we create it. And this is something that leans closer towards the end of the finality stages of this spectrum. As we start going through life, once we take a revocable trust and we make it irrevocable, it can no longer be changed. These are permanent wishes. Now, there's also, once you get to this level, something called crisis planning. And you will see many estate planning attorneys working on what are known as Medicaid Asset Protection Trusts, MAPTs, MAPTs, or Miller Trusts. These are the type of trusts. Medicaid Asset Protection Trusts need to be done 5 years in advance of qualifying for a nursing home event. So this is something that needs to be done before the need. But a Miller Trust, that's something that will income qualify people for Medicaid. That needs to be done at the time of planning. So when we look at our estate plans and you're saying, what do I need? Just for your information, the cheapest type of plan is a last will and testament. This is that simple document that just says, this is everything I want in case something happens to me. It provides you no protections and it puts you through a probate process. A revocable trust is a moderately expensive plan. This is something that is going to be a couple $1,000s because this will last you through your lifetime and you'll be able to amend it as you're moving forward. It completely bypasses the entire probate process. So it saves you a lot of money in the estate administration side. So it's something that attorneys do charge a little bit more for. Now, when you think of estate planning and you hear that plans are incredibly expensive, really overwhelming, the attorneys charged a lot of money, they are talking about irrevocable trusts and crisis planning. These are more expensive than anything else. These are the things that run in the upper five figures. Making sure that, like, not upper five figures like 90, but upper five figures like, $10,000 or so, because these are the things that are going to actually save you much more money than they cost. So when you do MAPS and when you do Miller Trust, these are things that will be helping you gain benefits. And in order to gain the benefit, you have to do a spend down. So attorneys charge a lot more money for that plan. It's also incredibly complex and something that attorneys really need to specialize in to do. So because of that, it's a lot more expensive. But not everybody goes to the nursing home. So if you are looking at just plain estate planning, you have a family, you have children you have to provide for, or you know that you have assets that you'll have to determine who's going to be your executor, you are most likely going to be in this area of the estate planning spectrum. And truly, the most important part of estate planning is not actually what happens after you pass. And this is something when you meet with attorneys, they will let you know this. When you're gone, I can change everything. I can make everything go to the next generation. When something happens and you're gone, I can make those things as an attorney. I can make them happen forward through the state processes. So even if you don't do any estate planning, an administration process will take over and will be able to move your assets to your next of kin. The problem is when you're not gone, but you are disabled. If something happens to you and you cannot make decisions for yourself, in that moment, if you have not pre-planned, I cannot do anything to help you. So what's most important, if you do nothing else, make sure you create for yourself a healthcare proxy, someone who can make medical decisions for you when you are unable to make or communicate that decision, and a power of attorney, someone who can pay bills for you or talk to your insurance companies if you are not in a place where you are able to do those things. A full and complete estate plan includes what do we do with assets after passing, but also how do we care for you when you are incapacitated during your lifetime. I hope this encourages you to go talk to an estate planning attorney because, quite frankly, we are not scary, even though the subject is scary. So please go look for an estate planning attorney and find out where on this spectrum you should fall to properly plan for your family.